Welcome to Premises Liability Cases Involving Third-Party Criminal Conduct. I'm Philip Vondra, and I'm delighted to introduce today's speakers, Robert Glassman and Nadine Khedry. Robert Glassman is a partner at Panish Shea Ravaputi, where he represents plaintiffs in large and complex personal injury cases and is a recognized leader in the Los Angeles legal community. Recognized by the Daily Journal as among the 2023 top 40 lawyers under 40 in California. Mr. Glassman has also been named a rising star in personal injury litigation by Law 360 and recognized as a rising star by the Super Lawyers publication since 2013, where he has been consistently selected as one of the up-and-coming 100 Southern California rising stars. The list of lawyers who rank at the top of Super Lawyer Rising Stars list. Nadine Khedry is an attorney with Panish Shea Ravaputi and focuses her practice on catastrophic personal injury, sexual abuse, wrongful death, dangerous condition, and product liability cases throughout California and Nevada. Since joining the firm, Ms. Khedry has worked on a variety of personal injury cases. Ms. Khedry is a member of the State Bar of California and Nevada, and an active member of Consumer Attorneys Association of Los Angeles, CALA. She also sits on the Consumer Attorneys of California's New Law Division Board and is a member of the Los Angeles chapter of the Assyrian Aid Society, which helps Assyrians in need and focuses on humanitarian concerns on the Assyrian people. And now let's get started.
Thank you so much, Philip. Thank you so much, Philip. Thank you for the kind introduction. Welcome, everyone, to today's session. We're excited to be here. So we're here to talk to you about premises liability cases and third-party criminal conduct that causes damages to people on the third-party premise or on the premise, and a third party commits a crime. In our case, is focused against the property owner, but the property owner is going to obviously deflect and blame everything on the third party assailant. And we're going to highlight one case that Nadine and I handled recently that illustrates a lot of these principles really well. And the case, for purposes of today, we're going to call it Jamie Smith, Sarah Alexander versus Bullseye Corporation. So about a couple of years ago, two families called our office and told us about a horrible set of circumstances that happened on the evening of November 15th, 2022 in downtown Los Angeles at a big department store. One family, unfortunately, had their son, whose name is Jamie Smith. We can go to the next slide, Nadine. Jamie was this cute little boy who was born and raised in Los Angeles, lived with his family here, was in the 6th grade, happy and healthy little boy, loved sports, loved playing with his friends. And unfortunately, he was in a department store in LA on that evening with his mom, and all of a sudden was brutally attacked by someone who had taken a knife from the shelf in the store and stabbed him multiple times up and down his body. Miraculously, he survived the attack, but he suffered tremendous injuries and will unfortunately have to live with those injuries for the rest of his life. He does have a form of paralysis now, and when you look at what happened to him, you just have to be thankful that he survived it, because it was a pretty bad attack. Unfortunately, Jamie wasn't the only victim of this attack on that evening. There was another young woman named Sarah Alexander who was in a different part of the department store after Jamie was attacked, and she was also brutally stabbed by this same guy who took the knife from the shelf in the store, and she too survived somehow. It's a miracle that she did, but stabbed multiple times in her back and through her hand, also has form of paralysis now. She was an amazing young woman, was in LA just, because of work, really. She was a flight attendant for Korean Air. She was visiting this, department store to get something to eat for the night because she was in a nearby hotel put up by the airline that she was working for. And it was just wrong place at the wrong time. Uh, she was the second victim to be attacked that evening. Was rushed to USC hospital. Was there for about a month. Had multiple surgeries. Somehow survived, and her life is going to be forever changed as well. So, we heard these stories from both of these families, and we, of course, did some investigation into the case, and the case was also on the news. So we learned some information about the case from various news stories. But we started focusing on the department store itself. So it was a large department store in downtown LA. There's an aerial view of it right there. Obviously, it's a heavily trafficked area. A lot of people go. It's probably a place that people on this Zoom have been to before too. But we knew basic facts. I mean, we knew these two people were in the store. They were customers in the store, and they were both attacked by the same man using a knife that he got from the store. So that was really it, as far as what we knew before kind of filing the case. Nadine, if you want to go down and just show just a couple more images of the store. I mean, yeah. So that's really it. We knew customers in a store stabbed by a guy who took a knife from the store. Whatever else we got from the news. Our clients weren't the best historians at that time just because they were still very traumatized about what happened. And, you're dealing with a little kid on one hand and a young woman who couldn't speak English that well on the other hand. So we had to rely a lot on what we could gather from the news.
So we were able to file the complaint a few months after the incident with the limited information that we did have, in hopes that we would find a better theory of liability throughout the course of discovery. All we knew at the time of filing was really that a knife was taken off the shelf and used by a homeless man in the store to stab these two individuals. So the claims that we ultimately ended up alleging were a negligence claim, that the store failed to properly secure the knives, store properly failed to have proper security, and then we alleged a premises liability claim, that it was a dangerous condition, allowing the knives to be accessible to the public in the store. And then lastly, we had a negligent infliction of emotional distress claim for the mother who had witnessed her son be stabbed in the store. And I think it's just important to note that sometimes you are in those situations where you file a complaint with limited information in hopes that you'll fine tune your theory of liability throughout the course of discovery. Sometimes it just pans out that way, where you're limited in the information that you can obtain without a subpoena. As Rob said, we were able to get some information from the news, but we still didn't have the final police report. We didn't have final police investigation, the photographs that were taken, the video from the inside of the store. We didn't have any of that. And so, upon filing the complaint, we went through and compiled what our discovery strategy was going to be. We had a few different angles that we thought would be viable avenues of liability. One being that the store didn't lock up the knives. Two being that the store failed to have proper security for being in downtown Los Angeles. That's a high crime area, and an area that had a number of previous incidents inside that shopping center in particular. And so the main two things that we were focused on in discovery were prior knife instances that had happened at that store and or nationwide stores of that department store. and 2 prior security instances that had happened in the store, that specific store or the shopping area. Those were the main 2 things that we were looking for throughout the course of discovery. And in gathering more information, we added additional theories of liability, but at the time that was the focus.
And one thing that became evident to us early on in the litigation is that the store was trying to frame the case in a very limited way. They took a very narrow approach to what the case was about, which was this exact type of attack has never happened before at this particular location. Remember, we're dealing with a nationwide chain. So they were saying this attack that happened on November 15, 2022 never happened here. And so it wasn't foreseeable that it was going to happen on this evening. And our job was to kind of expand the scope of the relevant, kind of facts of, well, it's not necessarily about whether this exact type of attack happened at this exact store. It's about whether people in general were able to also obtain knives or other weapons from the shelves at any of the stores across the country and use them in some kind of dangerous way in the store on either themselves or others. And the defendant really took the position that that wasn't relevant. What was relevant is what happened at this place only. And so that was early on, that was going to be a big fight. They were saying, let's limit it to this store only and what happened exactly. And we just kept pushing back and saying, no, this is about where other people at your company, whether it was in Los Angeles or San Francisco or Oakland, were other people able to walk into one of your stores, take a knife from the shelf and use it in some kind of dangerous way. It doesn't need to be precisely the manner in which it occurred here, but just that kind of broader definition. Take knife from a shelf, using it in some kind of dangerous way.
So we did our initial request for production, which is the standard reports, videos, surveillance of the incident, any witness statements, things of that sort. And if anybody needs any type of discovery samples, I'm happy to share anything that we talk about today that isn't subject to a protective order, including any type of motions that were filed throughout the course of the case. So after obtaining the video, we were able to go through it. Initially, we weren't able to get the entirety of the video. After a lot of meet and confer and additional depositions in which their employees testified that there was different video angles, we were able to get the rest of the video. And when we were able to get the video, it was determined that the homeless man that committed these acts walked into the store at around 6:16 p.m. You can tell there's a person right here standing here who is a security for the shopping center, and she actually noticed him prior to walking in to the store, to the point of where she made an announcement over her handheld radio saying that he was essentially acting bizarre walking into the store. He was spitting profusely or sweating profusely and then spitting on the ground. And so she alerted the security in the shopping center that this gentleman was walking into the store.
I think it's also important to note, Nadine, like that when you first watch this video, and just play it for a second here. So this is the assailant walking into the store. Okay, you stop it for a second. Like if you back up to the slide before this. Yeah, this one. I think it's important to know, when you watch this video, when we watched this video for the first time, we didn't know that this person on the left side of the screen was a security guard who made an observation of this guy walking into the store. Because when you watch the video, it's not really that apparent from just watching it that that's what's going on. it wasn't until we got this security report from the security company that works at this shopping mall that we found out that this woman was in fact a guard who did make an observation of this guy, radioed it in, and said, you know, she was concerned enough or had enough, uh, you know, you know, suspicion that this guy wasn't acting that normally. He was sweating profusely, as Nadine said. It says it right here, and spitting on the ground as he entered the store. It's not really normal behavior. And so once we were able to see that report and kind of juxtapose it with the video, it made more sense to us, and that was actually really good evidence for us that this guy was already acting strangely before he even walked into the store. There was a radio broadcast. Look, you know, we're just be on the lookout. There's a guy who's not acting right. Now, of course, the defendant was like, everything he's doing is fine. There wasn't anything abnormal or unusual about him sweating profusely or spitting on the ground. In fact, they were trying to push this narrative like, hey, there's a Gold's Gym at this shopping center, and maybe this is the guy who had just walked out of the gym from working out and he was sweating and he came up to the store to go get some stuff. That was one of the, you know, arguments that they advanced in this case. Turned out that was completely ridiculous and false, not true. But nonetheless, this is how we kind of like piece the discovery together, because sometimes you're going to get some discovery and it may not be that, you know, relevant seeming or important seeming at first blush, but it's not until you get another piece of evidence you're like, okay, now what I looked at before is actually very helpful for our case.
Initially, we saw the video, we saw him kind of walking quickly into the store, but then once we got the security incident report from the shopping center security company, it kind of all came together. And they were also a defendant in the case, which helped in getting this type of discovery. So I'll go ahead and play the video of him walking into the store. And we had an expert that put this together for us, with the map on the left-hand side up here.
Yeah, it was actually See Visual Evidence, who's a great company that we use to put together trial graphics and mediation videos and help us, you know, organize exhibits and show them at trial. See Visual Evidence are really good. So they put together this little Pac-Man video on the left-hand corner of his movements in the store.
So at this point, he's grabbing. Oh, go ahead, Rob.
Yeah, no, go ahead, Nadine.
At this point, he's grabbing the knife off the shelf. And then you're gonna see a Target employee, I'm sorry, a department store employee approach him. And this was also
this is one
protected.
Right. Like you don't really know what he's doing here watching the video at first blush. It's kind of hard to tell, but it wasn't until, you know, we got this woman's deposition testimony and we went into the store to look at that area of the store to see what was on the shelves, to kind of know what exactly he was doing at that kind of critical moment in time.
So this is when he starts the spree essentially throughout the store.
So that's the young lady that he just stabbed. And we had to piece this together from like hours of surveillance footage because the defendant produced hours of footage from that evening from different camera angles, and it took some time to kind of put it together in a chronological way. This is when the assailant confronts the armed security guard who was at the front of the store. Security guard shoots him, and the assailant was killed by the guard, and that kind of concludes the end of the incident from the evening.
So initially looking at this, like Rob was saying, this kind of took hours of piecing together, and it wasn't until we completed all the depositions of the employees that were at the store that night that we got a clearer idea. That woman that confronted him at the time when he was grabbing the knife off the shelf testified at the course of her deposition that she walked away from the time that he was grabbing the knife off the shelf because she thought to herself, well, that was AP asset protection's problem, and she didn't want to deal with it essentially. And so it wasn't until we got that testimony that we went back, realized, okay, this woman was the same woman who confronted him and ended up walking away. And I think you guys saw it. She was walking to the back room with the bucket in her hand, very lackadaisical, with no sense of urgency that this man was about to go on a stabbing spree, opening up a knife off the shelf and acting in a very neurotic and, you know, really just unpredictable way. So these were the knives that were on the shelf at the time of the incident. You can tell there is no type of security measures that were placed. Sometimes the stores will have those knobs that prevent you from grabbing it off these pegs here. Other times they'll be an acrylic casing, but in this case, it was just free to grab. And the theory of the case was that the store failed to secure these knives, but they chose to only lock up high theft items. So throughout the store and throughout the depositions, we were able to figure out which items were under lock and key. And that was detergent, and that was beauty products, and that was men's underwear and men's t-shirts, a variety of things. And throughout every deposition, every employee confirmed that the reason the department store locked up certain items was solely for theft reasons. They would track theft trends religiously and determine which products were high theft items, and depending on the metrics would change which products were locked up or not. Every single employee testified that there was never a product that was ever locked up for safety purposes. So this was shortly after this stabbing. These were photographs that the police took. All right, so I want to jump into some of the discovery. Discovery was very difficult when you're dealing with a big box retailer like this. The MO really is that they won't turn over the discovery because they rather you spend the time to go get the motion to compel, present it in front of the court. And unfortunately, the sanctions that are even awarded in those types of situations just aren't enough to deter them from their behavior. I mean, we got a number of different sanctions throughout the course of this case, but unfortunately, $2,000, $3,000, $4,000, $5,000 worth of sanctions just isn't worth it for them. They'd rather take the risk and get sanctioned than provide the information over to you and force you to file motion to compel after motion to compel. Robert and I filed a preference motion in this case, and so we were on a shortened timeline, which added to the pressure because obviously, as most of you know, LA courts are really backed up. You come to reserve a motion, it's likely after your trial date. And so every time we wanted to file a motion to compel, it would be an ex parte to advance the motion. The ex parte would have to get granted. Then the court would have to do a shortened timeline for the motion to be heard, and then the motion would be heard. I mean, this was a reoccurring process, probably at least once a week throughout the course of the case. I think we had probably about 12 motions to compel by the end of the case, and the judge was very upset with the behavior and awarded sanctions, but unfortunately, like I said, just not to a degree that was severe enough for them to change their behavior. So, this was one of the requests for protections that we did, which was relating to past incidents of stabbing, shootings, assaults, or any other types of violent occasions at the subject store. This was after, they produced initial responses, which were basically just objections only. After meeting and conferring, they provided further responses. And as you can tell, it was a 2-page incident report, which involved somebody hitting someone with an electronic scooter inside the store. So that required further meeting and conferring to figure out what other instances had occurred at the subject store. We also requested a number of different documents pertaining to incidents like this at nationwide stores. I would say that that was probably the biggest discovery dispute that we had in the case, which was what was the scope of what was discoverable as it pertains to geographically, what was discoverable, whether it was nationwide, California, Southern California, the district where the store was, or the other thing was what types of incidents were we allowed to get into? Was it every type of shooting, every type of stabbing, any type of incident with a knife? I think we took nearly 60 depositions in this case, which was the lower level employees that were there at the time of the incident, then the regional people that were supervising at the time came out to the store and did further investigation, and then more senior management up until the corporate level. And throughout the course of those depositions, we discovered that big box retailers like this have a lot of different databases. They have databases that store this type of information, these types of incident reports. And so once we were able to figure that out, we did further discovery as to what exactly would be in those databases and how we could obtain it. Eventually, we got a court order that the scope of the discovery was 5 years prior to the incident, any and all incidents involving knives nationwide. And they had to turn over the results within the database that search terms that we agreed to within the database and the results of those search terms, which ultimately had thousands and thousands of results, some of which, not even some, most of which were not relevant to our analysis. A lot of them were, somebody walking in with their own knife. Some of them were, using a knife to open up a package that they were trying to steal, things of that sort. But we really had to dig through and find the ones that were relevant to our theory of liability, which was, as Robert mentioned, framing the bigger issue, right? Which was taking a knife off the shelf and using it in any type of dangerous way.
I mean, the defendant knew that the narrower the scope was, the better it was for them. And that's why they kept kind of trying to hold us to this unrealistic and improper standard, which is we're not on notice of this type of thing happening unless you can provide us with some evidence that this exact thing happened at this exact store before this incident. Well, of course, this exact thing, more likely than not, is not going to have happened at this exact store before. I mean, this is the first time that this exact thing happened. But what Nadine found out through going through scores, thousands of incident reports is that what has happened before a lot was people walking into stores nationwide, taking knives off the shelves and using them in some kind of dangerous way. That's it. Then ultimately the judge agreed that that should be the proper scope of the inquiry and allowed us to get this discovery after pretty aggressive motion practice, seeking this information, because we knew that at this particular location, this exact thing just didn't happen before. But when it comes to a big box retailer, an incident that happens in New York is imputed on the corporation, period. And in here, they were trying to act like, well, this little store is its own little fiefdom. It's its own little entity. And it wasn't. It wasn't like it's its own franchisee. It's not like it was owned and operated by a separate LLC or corporation. No, the company didn't do business that way. The company owned and operated each of its stores nationwide. So something that happened in Florida is imputed on the central nervous system in its headquarters. And so, that took a lot of wrangling and fighting over. And the judge, like I said, ultimately said, no, it's one defendant with multiple locations. It's not, multiple little entities. And if something happens in one place that, it's not like that doesn't count. It does count. It certainly counts. And we found, how many was it, Nate? I mean, like,
It was over 30. Yeah.
over 30 prior incidents of people going into stores, taking knives off shelves and using them in a dangerous way. And yet, as Nadine pointed out, the store continued to not make any changes to the merchandise protection. They locked up laundry detergent, they locked up cell phone accessories, they locked up batteries because people stole those things a lot. But the one thing that people were, criminals were using to go in to, cause carnage and wreak havoc were knives, and those weren't being protected in any kind of reasonable way.
A lot of objections throughout the course of discovery. And these were the multiple prior knife instances. I mean, like I mentioned, there was over 30. And so I kind of just want to talk about how we were able to get some of those prior knife instances. It was a lot of creativity and a lot of motion work, as I was mentioning. A lot of them came from the database that I was talking about earlier, going through the search terms. After we went through the search terms in the database, we asked that Target produce the department store produce the incident reports related to the results that came up from the database. Also, just being creative and trying to find other incidents, whether that was through Google, searching Facebook, looking through court records, trying to find any prior lawsuits. There was a number of instances that I found through just news articles. And a lot of times the news articles, the biggest issue was sometimes we couldn't confirm whether it was a store knife or not. And we would have an issue where it seemed like it was the assailant bringing in their own knife into the store. And there was one instance that I had found. The news articles weren't able to confirm whether it was a store knife or not. I figured out that there was a criminal case related to that incident, and I ordered the preliminary hearing transcript from the criminal case, and the preliminary hearing transcript confirmed that it was in fact a store knife. Target didn't produce obviously any of that kind of stuff to me, but if you're able to, do the grunt work and get the public records, you're able to find out a lot of great information that way. So as I mentioned, these were a number of different motions that we had to bring. It was compelling prior instances, the time, the locations, the inspections of the databases. I hope that I can one day get to do this again, because we asked, they had been so evasive throughout the course of discovery, and the judge had caught on to that. And you got to, you can't come out swinging, really. You got to build it up with the judge and build the credibility to come in and ask for something to this degree, because they had been so, deceptive with their discovery throughout the course of the case. And so I basically pled to the judge and said, look, they can't be trusted to produce what they need to produce. We want to have a forensic expert go in and inspect their databases ourselves. And the tentative was to grant that. Which I was kind of surprised, but I was thankful. And then we went in that week for the hearing, and I don't know if you all remember that week where the courts were hacked and there was a data breach. And so they used that to their advantage, and the judge ultimately ended up flipping and said, you know what, you just need to produce the results. But I think it's a tool to keep in your back pocket, that you can have a forensic expert go in, and they can have their own forensic expert go in and download the information from the database, so you have that raw data. And then the last was just motions to compel employees who were involved in the prior instances. That was also good information that we were able to get. I mean, of the ones that we were able to track down, a lot of the employees didn't work at the stores anymore, but some of them did. And the depositions we took were really helpful because they would testify that, for example, there was one instance in Seattle where the assailant took the knife off the shelf and began threatening hostages. That was pretty much all the information I had. And then once I took the deposition, the employee testified that the incident went on for hours. He was attempting to hold, a number of different customers hostage. The police came, there was a standoff. And then, the kill question was, well, did the store lock up the knives after that incident? And it was no. So, that's the information that you're able to get in the deposition versus just a concise incident report. So this was the court order that we got regarding the database. It was called Origami. It's a risk management database, basically. And like I said, we got the instances for the past 5 years within the United States. Rob, you want to talk about the MSJ a little bit, or go we keep going?
Yeah, sure. So, we knew the defendant was gonna file a motion for summary judgment. You can anticipate in any premises liability case involving third-party criminal conduct, the premises owner is likely going to file a motion for summary judgment. And look, I mean, this goes without saying. We haven't said it yet, but it does go without saying. In these types of cases, a lot of the focus and emphasis is going to be on the third-party criminal, what he or she did to your client. And that's that's going to be a big hurdle to overcome in a lot of these cases, because when a jury hears about someone, taking a knife from a shelf and stabbing your client with it, their natural inclination is going to be to blame the person who did that. So these cases are very difficult to prosecute. Our job is to shift the focus from the third party criminal onto the premises property owner and what they could have done to have prevented this type of foreseeable attack. So when the motion was filed, they advanced arguments that we knew were coming. One, we didn't have a duty to prevent this type of thing from happening. It was completely unforeseeable that a crazy guy was going to come in and take merchandise from us and use it as a deadly weapon on other people. It's never happened before here. It wasn't anticipated. None of our people, were on notice that he was going to do something like that. And once he did do that, the security company who we hired immediately dismantled the situation. I mean, they as you saw in the video, security guard went up to the guy and took out his gun and shot him, and he is killed. Threat is abated. No more issue. So that's what the defendant was arguing, that, we didn't know it was going to happen. It's so unfortunate. It was a crime. A crime happened in our store. We didn't know that was going to happen. Once it did, Nadine, what was it, like 3 minutes? The time was again. From the time the guy walked in to the time he was shot and killed, it was like 3 minutes. It was tough. So, they're like, he walked in, he was, acting pretty normal. He could have been working out. That's why he was sweating. There's no crime against sweating and spitting. And, by the time he took the knife, did all that, our guy came to apprehend him. He tried to de-escalate the situation without shooting and killing him, but the guy lunged at him with the knife because he was crazy. So our guy shot and killed him. Threat is eliminated. The end. It all happened in 3 minutes. How are we negligent? This is all the criminal's fault. So notice was obviously such a big issue in the case, and that's why Nadine spent just the last few minutes talking to you about how critical and important the discovery is to get that prior, get the evidence of prior instances of this type of thing happening before. We needed that in order to succeed on the motion. We also knew that, you know, a business establishment owes a duty, in fact, has a special relationship with people like our clients, with their customers, to keep them safe in their store. And, you know, the defendant here was arguing that they had no duty. They failed to mention the special relationship doctrine at all in its moving papers. We brought it up really for the first time in the case in our opposition. And the judge ultimately, I mean, we're going to get to it, but the judge ultimately sided with us and said, no, you as a business owe a special relationship. You're in a special relationship with your customers, with your invitees, and so you owe them a duty. So now the question is, like, was this foreseeable? Could you have done more? And thankfully, because of the evidence we uncovered about the prior instances of attacks and using knives in dangerous ways, we had enough evidence to create, you know, I think, numerous tribal issues of material fact. And so, you know, obviously, it's always a scary thing when you're hit with a motion for summary judgment, especially in a premises case involving a third-party criminal act. It's risky, you know, because you always think about, well, you know, was this thing truly, you know, preventable? What's the jury going to think? Are they going to put like 90% on the perpetrator and 10% on the property owner? Those are all things that were swirling around in our heads, but I think we were comfortable with the evidence that we had uncovered to date by the time it was to oppose this motion. And obviously, Rowland is an important case that we're going to talk about that discusses numerous factors that you can use to hold property owner liable, even in the face of an egregious third-party criminal act like we had in this case. This slide here is actually from the court's tentative ruling to deny the defendant's motion for summary judgment. And as you can see, it's kind of small, but what you can see, the judge said, as an initial matter, as discussed above, there exists a special relationship between the defendant and plaintiffs who were customers of the defendant, which gives rise to an affirmative duty by the defendant. Okay. The question then becomes, what specific duties do the plaintiffs claim the defendant had, and do relevant policy considerations counsel limiting those duties? And those policy considerations is where the Rowland factors come into play. But this was like an very important finding, because the defendant was saying they didn't owe an affirmative duty to our clients, to their customers, to do anything beyond what they did, which was, we had a security guard with a gun, and that was it. You know, what more could we have done to prevent this? And turns out they could have done a lot more. They could have locked up the knives. The video we showed you of the assailant taking the knife off the shelf, I mean, just to kind of give you a little bit more color as to like what went down during that critical period of time. This was all information we obtained during the discovery. We didn't know this before we filed the case, but what we found out is that that guy was, you know, took a knife off the shelf, used his teeth to try to open up the package while he's sweating profusely, using tons of profanity as he's trying to rip open the knife package with his teeth, all in front of an employee working for the defendant, as you saw in the video. And again, the video you can't really understand that by watching the video because there's no sound and it's from far away and you don't really know what's happening. But when we took that employee's deposition, she tells us, yeah, this guy was ripping open the knife package with his teeth, sweating and saying, "Go fuck yourself," to me, and acting like a madman. So the next logical question we asked in the deposition was, And what'd you do after that? And she said, well, I thought to myself, this is someone else's problem, and I walked away. I mean, when that happens, like, it's like, the case stopped for a second, and it was like, oh my God, that is such a horrible mistake. That is probably the most pivotal mistake that you made in the entire case. You were there watching this guy opening up a knife package with his teeth, sweating, cussing, saying, go fuck yourself, fuck you, blah, 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 all this stuff. He wasn't ultimately successful. She witnessed this too. He ultimately wasn't successful opening the package with his teeth. So he took his backpack, put it on the ground, unzipped it, took out scissors from his backpack and started cutting open the knife package like this in front of her. And she walked away. She put up her hands and said, this isn't my problem. I'm, probably I'm not paid enough to deal with this shit. And she walked away. She didn't tell anyone. She didn't alert any customers. She didn't, sound the alarms, which, by the way, is against the defendant's policies, because we also got their policies and procedures. And it clearly stated, as it should, that if you see something suspicious, say something, alert the customers, alert people to clear the area. She didn't do that. And what happens after she walks away? He takes the knife from aisle J, finds the little boy, stabs him multiple times, goes to a different part of the store, finds the flight attendant, stabs her multiple times, and then thankfully he was fatally shot. But the damage was already done. Too little, too late, right? So that was that was a bad thing that happened. And of course, the defendant, they tried to spin it as best as they could. And they said, well, she didn't know. It wasn't reasonable for her to know that he was going to take that knife and go and do what he did with it. She thought that he was just simply trying to steal the knife. So there was no real reason to sound the alarms because he was simply going to just steal the knife. Well, we know that that's not true. We know when you look at the evidence, it's obvious that that's not what he was doing. If he was going to steal the knife, take the knife off the shelf, put it in the bag, walk away. That's what you do when you steal a knife. What he was doing is he was, prying it open with his teeth, with a pair of scissors, sweating, cussing at store employees, telling them to get away from him. That's what you do when you're going to use that knife in some kind of dangerous way. And I think ultimately they knew that, and they knew they were screwed. But so that's all important because that all goes to what more they could have done. So once we found out what their employee did, which is basically walk away from the threat as it was unfolding, we were like, okay, now there's multiple things that you could have done to have prevented this. Number one, and this is something you could have done prior to the subject incident, you could have locked up the knives. And you should have locked up the knives because this happened over 30 times before. How many more times is it going to take for you to learn? Lock up the knives. You lock up the laundry detergent, you lock up the batteries, you lock up the cell phone accessories, lock up the things that could actually kill your customers in your stores. That's number one. And you failed. Number two, and this is something admittedly that you couldn't have done before the event, but you knew about the event unfolding when it was happening. Your own person saw this guy getting ready to carry out this attack. Your defense to that he was simply just trying to steal it, is complete bullshit. Everyone knows it. He was clearly, in a menacing way, trying to take this knife out of the package to use it in some kind of dangerous, horrible way. And you didn't do anything. You didn't intervene. You didn't alert our clients, your customers. You didn't alert anyone. It wasn't until this guy unfortunately stabbed two people that the security guard at the front of the store was finally made aware of what was happening inside of the store and came to uh, to try to de-escalate the situation. So, that was like, I think that was just so important. It's such an important foundation to like understanding why the defendant bared responsibility in this case, not just the third party criminal. And so we actually started our motion, our opposition to the motion for summary judgment with those details. I have it printed out here and I'll just read it. This is how our opposition starts to the MSJ. A visibly deranged man was sweating profusely and shouting obscenities while feverishly using his teeth and a pair of scissors to rip open the packaging of an 8-inch carving knife he took off the rack in aisle J at the department store at Fig and 7th. When the store's executive team leader confronted him, he mumbled, quote, "Fuck you, leave me alone." The employee thought to herself, quote, "This is someone else's problem," and walked away. The man, later identified as a transient, then took the knife out of the aisle, walked to another part of the store, and violently stabbed a 9-year-old boy in his spine, causing life-threatening injuries. And so I think like kind of we set the scene up nicely for the judge to think, all right, obviously we know the guy is a bad seed and maybe a jury's gonna, allocate some fault on him. Not maybe, probably. I mean, we were contemplating that. We didn't know how much fault would ultimately be put on him. The more we were working up the case and prosecuting the case, I think the worse it got for the defendant. The more bad stuff came out. You had the 30 prior incidents. You had the confrontation of the perpetrator getting ready to carry out the attack, and what do? Nothing. They just tried to spin the facts to make it seem like it wasn't as bad as it actually was. And so I think it started to get really bad for them. And so we had a lot of good evidence to use in the opposition. All right. So judge found, which is great in the tentative, that they owed an affirmative duty, which is awesome.
So
yeah, Nadine, why don't you talk about this great case that you found?
Yeah, this was a great case. So, I mean, throughout the course of discovery and a lot of the motion work, the issue was the defendant was using the admissibility at trial standard versus the discoverability standard. And I was able to find some case law that helped us. The case law talked about even admissibility at trial being broader than what the defendant thought was discoverable. And so this was a case that if you have a third party criminal conduct case, keep this case in your arsenal. This is a case involving someone coming into a 7-Eleven store and attempting to rob the 7-Eleven. The Court of Appeal found that just with one prior incident not involving a weapon, and coupled with the fact that there had been other robberies at other 7-Eleven locations generally, this was a foreseeable issue, and it was something that was a tribal issue of fact for the jury. And so that language, those 4 words, other 7-Eleven locations generally, is enough for you to convince your judge that you're entitled to discovery of nationwide instances in any type of big box retailer, any type of store like a 7-Eleven with multiple locations. And that way you can cast your net into a wider, array of instances and to see what you can find and to show that the corporation should have been on notice. So these are the Rowland factors, also a case to keep in your arsenal. And this basically are the factors that decide whether a duty is owed by the defendant in protecting individuals, invitees to their store. And so there's other case law too that says that duty of foreseeability is a question of fact for the jury. And I think because of that, we were able to get past motion for summary judgment. I think even without the prior instances, we likely would have gotten past motion for summary judgment just because of the evidence that came out about what the employee did at the time of the incident and confronting the gentleman. And so, B was really what we focused on. Well, A, the special relationship that the court found, and then B, the foreseeability of the harm. That's where we were able to stick in all the prior instances. And the rest are kind of more policy considerations. This is a really important case that talks about what type of defendants have a special relationship with their invitees. It's shopping centers, restaurants, and bars.
And yeah, I mean, so like the Cohen case that Nadine just talked about, Rowland, obviously, and Delgado, I think these were the three most important cases we used to defeat the summary judgment in the case, because I mean, on the Delgado case, I mean, again, like you got to think this is a case that we focus grouped. I mean, it settled, I think, one day before jury selection was set to begin. And we tried out a couple different theories, and one thing that just kept resonating with prospective jurors in the focus group and with us is like, look, if you open up a business and you invite people to come there, you got to keep them safe. It's as simple as that. When you run a business in this town, when you run a business in this city, you have to keep them safe. You are in the law. The law even intervenes and says you owe them you're in a special relationship with them to keep them safe. And the law even contemplates that sometimes bad things are going to happen that seemingly on the surface might be outside of your control. Like a criminal might walk into your place of business and do bad things to other people inside your store. But that doesn't mean you get a get out of jail free card just because a third party comes in and does bad stuff. The law contemplates that because it's happened before, and there's policy reasons why the law is the way it is. And so like this would have been a special jury instruction. And this is something that we did propose in our trial documents. Like the jury needs to understand that, a defendant owes an affirmative duty to protect another from the conduct of a third party if it has a special relationship with that other person. So, I think that was a really important concept for everyone, whether this case, whether you're trying to get past summary judgment or you do and then you try it. It's an important concept for everyone to understand, is that these types of big box companies like Nadine's talking about, they have this special relationship with their customers to keep them safe. And that means that they have to take precautions before the event happens and take precautions at the time the event happens. And here, because of the discovery we propounded and pursued, we had evidence of both things that the defendant could have done before and things that they should have and could have done during to minimize the severity and extent of the attack. So again, it was kind of like two phases of evidence, the stuff before and the stuff during. And I think the evidence was kind of overwhelming that they really dropped the ball in both phases, both things they could have done before and things they could have done at the time. As you can imagine, we got past summary judgment. Judge denied the motion, and like I said, it resolved one day before jury selection was set to begin.
These slides kind of just go through the incident.
Yeah, if you go back, Nadine, to the arrows with the employee and the assailant.
Going back in a second.
Yeah, I mean, this was a big slide we made from the surveillance footage. We actually, at the motion for summary judgment, we had a big, you know, uh, styrofoam board with this image printed on it, and we brought it to the hearing and put it on an easel to kind of just underscore the importance of this critical event at the time of the incident. Um, I mean, because again, when you watch the video, you don't really know what's happening. You have to kind of take all the evidence together to know the import of it. But this was just such I think, visually such an important part of our evidence that the guy's reaching down to get a pair of scissors from his backpack to open up this knife that he just took from the shelf freely. There was no case, there was nothing. He just took it off the shelf, reaching into his bag to get a pair of scissors to open it up after he couldn't open it up with his teeth. And this employee is just standing there watching him do this, watching this whole thing unfold, and does absolutely nothing with what she observes, walks away. And sure enough, within 10 seconds after she leaves, he walks out of this aisle with that knife that he opened up in front of her and brutally attacked and stabbed two innocent people.
I think we got a couple more slides. We're running low on time. We just wanted to see if there was any questions that anyone had. If anyone needs motions or opposition to summary judgment, just let us know.
As Nadine said, there was a ton of motion work in the case. So there's probably a half a dozen to a dozen motions to compel, multiple rounds of written discovery. There was a protective order in the case. So some of it we can't give out, some of it we can. But obviously our opposition to the motion for summary judgment is available for everyone who wants it. I think it's a good one. It outlines all the important cases, and I think it's structured in a way to really successfully overcome these tough liability cases involving third-party criminal conduct on someone else's property.
Yeah. I think there was a question about that. In hindsight, it seems like this case is a slam dunk, but it's establishing liability wasn't so clear. And I think that's right. I mean, looking back, you're probably thinking, yeah, this seemed like an easy case and something that the store should have been made aware of. But on day one, that was definitely not the case. And so, what keeps us confident in cases like that is just to keep pushing, honestly. I think it's really important to take every deposition that you possibly can of every employee, every regional employee, every high-level employee. You're eventually going to find some theory of liability that the store did something wrong. And I think also, too, the fact that it was a national corporation also kept us confident because there was going to be something that the corporation had done prior that would have put them on notice. And I think sometimes, too, the theory you have to frame is, well, not that they necessarily should have done something, which was the case, but also too, they didn't do anything with the information that was presented. There had been 30 prior instances, and Rob took the deposition of one of their national corporate representatives who was the head of their risk management and just went through every instance and was like, this was in your database, correct? That's a database that's accessible to you. That's a national database. And you failed to do anything with that information. You never did a study to ensure that stores locked up their knives, right? So it's also the lack of action.
Yeah, I mean, that's a really important point, Nadine. Like, you can't let the defendant hijack the narrative of your case. You can't let them dictate the scope and what's relevant and what's not. You have to be the one to define the scope and to define the narrative. Like, case in point, in this case, we had like 30 prior instances of people taking knives off shelves and using them, right? And the defendant in our case was saying, so what? that didn't happen at this store, and it didn't happen in the exact same way. It's irrelevant. And they just kind of acted like it was no big deal. And, you know, they were good lawyers, very formidable, and they knew what they were doing. And, like, you know, if you're kind of on the weaker side, they could push you around and make you believe that what they're saying is true. But once you like looked at the information, I'm looking at like some of, I'm trying to look at some of the prior instances. Like, for example, just one second, like, you know, a couple years before the incident, there is an incident report that documents a man walking into one of the stores, went to the kitchen department, grabbed a knife off the peg hook, took the knife out of the package, and ultimately stabbed and killed himself. He used it to commit suicide inside of the store. The defendant said, that's not relevant, so different from our case. We disagreed. And so, again, because our theory was, how many times are you going to let someone take a knife off your shelves and use it in some kind of dangerous way? Using it in some kind of dangerous way includes killing yourself with it. You know, it's one of your people, one of your customers. So, I mean, when you have such a wealth of information, like Nadine just said, with the PMQ for the company, you don't need to really even need to get them to make any kind of crazy concessions or admissions. You can just simply walk through each of the prior incidents and say, as she just said, this is in your database. This happened before the incident. And the database is available to every store in the nation? Yes. And the database is accessible to anyone if they just want to search the word knife? Yes. It was there to be seen if you wanted to look for it, right? Yes. Okay. I mean, they can't dispute what's in their own documents. And that's why, I mean, this basic stuff, but it's important to remind ourselves of it. You got to get the documents before you take the depositions, so you can simply just get the confirming oral testimony of what's in the actual document itself. And that's really all it was. I mean, it took a lot for us to get the information, to get the documents. But once we had all the information in the documents, they thought they were being smooth by saying, oh, this doesn't count, it's not relevant. But as soon as they authenticated the document and said that the information in it was in their own database prior to the incident, that really screwed them. That notice, whether it was constructive or actual, was imputed on the entire company.
I think we are over on our time, but we really appreciate everybody jumping in. You can contact myself or Rob for any other questions that you have. Like we said, we have an open door policy about sharing anything that we can, anything that's not subject to a protective order. We're happy to share with you all. Really appreciate everybody jumping on. I don't know if Rob had anything else.
Not at all. No, it was good to be with you all this morning, and please reach out to us if you have any questions or want anything. I saw a question about the opposition to MSJ, if that was included in the course materials. I don't know if it was. Nadine, do you know? If it wasn't,
I don't think it was, and you can email myself or Rob, and we'll send it over to you. And Rob's email is rglassman@panish.law. Mine is nkhedry@panish.law.
I see a question that says, what is Rob? That's a question for the ages. We don't know. We're still trying to figure out what Rob is, but no.
I think it was, what is Rob's email? I answered it.
I know. I know. I'm kidding. All right. It was good to be with everyone. Have a good rest of your week.
Thank you, everyone. Take care. Have a good one. Take care.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.